Hello and welcome. You're with We Mean Business. I'm Shweta Rajpal Kohli. The big news for today is that the much-awaited report of the Shome panel on retrospective tax amendments has finally been made public today. What are the key recommendations and does it satisfy corporate India, tax experts and analysts? That's something we'll try to debate on the show over the next 1 hour. Let me quickly introduce our special guests on the show today. We have with me here in the Delhi studio, Balbir Singh Mastana, partner, DSK Legal, also Aseem Chawla, partner, head tax practice of MPC Legal, Mr. TP Ostwal, senior partner of TP Ostwal Associates, also joins us from Mumbai. Ketan Dalal, joint tax leader of PwC, joining us from Mumbai. We're also hoping that Anuradha Dutt, partner of DMD Advocates and the counsel for Vodafone, will be with us shortly. And of course, with me in the studio, also our in-house finance expert, Sapna Das. Before we move forward and try and debate, let me go across to Sapna, who will take us through some of the key recommendations that have been made by the Parthasarathi Shome Committee. Sapna, it's over to you.
Right. In fact, this is a much-awaited report, and the ministry has given time to stakeholders to get back with their comments till the 19th of October. They've also indicated that they plan to finalize the report by the end of this month, the final recommendation that should be in place. That's one. Second, of course, what basically the Shome panel has recommended, that everything should be prospective. There should not be any question of any kind of a retrospective taxation on any of the indirect transfers of shares or assets. They're very clear on that front. However, they've gone ahead and added certain caveats, certain exceptions and also certain relaxations, basically in the sense that if the government is not able to make it prospective immediately or later on, if there's a problem in terms of trying to amend the Finance Act and hence help out the Income Tax Act. On that front, the exceptions that they've made, they've defined that the value of the underlying Indian asset should not be less than 50% or more. This is also what the original direct tax proposal says, and this has got the standing committee's nod also. That's one. Second, it says that foreign companies which are listed in any of the recognized stock exchanges, there cannot be any retrospective taxation on those companies. Third, retrospective taxation will also not apply to business reorganization. Fourth, small shareholders having less than 26% shareholding in the foreign companies will not come under the retrospective ambit. What are the relaxations that it talks about in case the retrospective amendment actually goes ahead? First thing is that the levy of the tax will only be on a proportional basis, which means that since the underlying assets in India should be 50% and more, and suppose you have earned a capital gain of 100 rupees, then only 50% of that will be taxable, not the entire amount.
Path-breaking, really, shall we say?
And also, it also says one very important point, Shweta, sorry to interrupt. It also says that it says very clearly that withholding tax cannot be applied retrospectively, which means it gives a very clear verdict on the Vodafone tax matter.
All right, so clear verdict on the Vodafone tax matter. We're hoping that the Vodafone Council will be there to take us through whether it is really the way we are reading it or not. But first, let's go across and listen to what the big man, Parthasarathi Shome, told my colleague Sapna Das a little earlier in the day. Let's listen in.
Our point is very clear on withholding tax. What we have said in the report is retrospectively to ask a kind of implied representative assessee, or make that as a judicial person, into an assessee itself is simply something that is impossible for such an assessee, for the task to be performed. Therefore, we are saying that retrospectively, certainly that should not be applied.
So this basically means that Vodafone should not be brought under the retrospective tax net. I mean,
no,
of course,
this is not the report.
Of course, it's not company specific, but it's very important to get your view on this.
No, there is no view. It is right in the report which company fits into what recommendation. You all have to make a matrix and see which company. I don't want to take up the name of any particular company in this.
Right. So going on to the next question, you've also spoken about the fact that how interest and penalty should be waived in cases where the taxation will be applied retrospectively. So here again, there is an expectation that CBDT will come out with a circular that can be done internally by the government.
No, the issue there is that where there is retrospective taxation, if government opts for retrospective taxation, so for due caution, what we are saying that if government opts for it, then certainly interest or penalty should not be applied on it. That's all we are saying. And but of course, we've said that our first preference is prospective.
So one last one, the positive signal for the markets in the sense that PE funds and FIIs you have suggested that they should be exempt. Plus the fact is that there is also a high threshold threshold that you're suggesting, 50% or more in terms of the underlying assets should reside in India out of the global assets, and second, the 26% shareholding. How critical is this? Basically, you're trying to filter out also a lot of such litigation that may arise out of not just retrospective but also prospectively. Could you please explain the policy?
Yeah, exactly.
The perspective?
Yeah, very good question. Prospectively also what we are saying is that you don't want to go after every case of every transfer. So where do you hit the mark? OECD has a guideline of 50%, and that too it was only for your real estate type of oriented properties. But in this case what we are saying is not only that, but we are taking all assets 50% and the 26% also, because we took it from the domestic company law where 26% can actually stop some resolutions. So we are saying you have to really look at the big issues. The tax department then can focus in a very efficient way in the big questions and the big challenges, rather than going after every little case. And this is international norm again. I mean the OECD norm, and it was also in the DTC bill 2000.
All right, the man of the moment, Parthasharthi Shome, there in conversation with Sapna Das. Before I go across to Anuradha Dutt, the Vodafone counsel, to make sense of what this really means for Vodafone, a quick word from Sapna once again. Sapna, your understanding of what today's recommendations really mean for the Vodafone case, because for all of us, it is really something which has become synonymous with retrospective tax amendments, right?
That's right. Well, clearly here the recommendation is very clear that it should not be done retrospectively. In the sense that there is no question of levying or trying to extract withholding tax from the company which is actually buying out. The entire owner should actually devolve on the seller, which was basically Hutchison over here. So that's where it actually leads towards it. And there also they are saying that in case retrospective application is made, it is only for the seller, not for the buyer. Again, I would like to kind of differentiate. Second, there also they are saying that in case you actually go ahead and collect the basic tax amount, that is what the suggestion is. There should not be any penalty and interest. And in case the government accepts this will not just be for one or two companies. It will have to be across the board. So there will be a CBDT circular later on. This is also suggestion made in the Shome by the same Shome panel. It's part of the report right now. But we have to wait and watch and see what stance the finance minister takes on this. Whether he would like to actually make the amendment and make the entire thing prospective and wait for the next 5 to 6
so what
months.
are the options before the government now that the Shome panel report has been made public?
Basis.
That's something we're going to ask all our panel of experts. But first, over to Anuradha Dutt for her first reaction to these recommendations. Does it sound as music to your ears, Anuradha?
Well, I do welcome the recommendations made in the report. I think it's a step in the right direction. I fully agree with the panel which says that, just not in Vodafone, retrospective amendments should be discouraged. They should not be, put in place to widen the tax net, but should be really in rarest of rare cases. So I think that is really where the starting point is.
Okay, so Mr. T.P. Ostwal, let me get your response as to now the options before the government, specifically with regard to the Vodafone case. So let's discuss the Vodafone case first, and then we come to the larger implications. Given the Shome panel's recommendations, how do you see the government moving forward on that particular one?
The government has two options. One option is, in my opinion, is difficult, and that is saying that these amendments will apply prospectively. And if that is to be done, then that has to be done through a parliamentary process. It is through the amendment in the Income Tax Act. I do not know whether the Parliament will accept such a proposition, but nevertheless, it is one of the best recommendation I can tell you. The Shome Committee has done it, because the retrospective amendment is nobody's interest. You cannot make a dead man alive retrospectively. Likewise, you cannot impose a tax, withholding tax obligation on somebody retrospectively. When the transaction is already over, payments have already been made, the recipient has received the money, how do you expect the retrospective withholding of tax? So therefore, what the government, the Shome Committee has recommended, two things. Either do away with the recommendation or do away with the retrospective amendment, even including this section 9(1) amendment. And therefore whole problem is resolved. Then there is no question of interest, penalty, so also question of demand would arise. Second option is, in the event suppose you have difficulties in not accepting this recommendation of going prospectively, you still hell bent on making this retrospective amendment, then certainly you cannot impose an obligation on a taxpayer to withhold the tax retrospectively, and in case if he has not done so, interest and penalty both cannot be levied, and that's correct, and therefore that provision will arise. But the interesting issue will arise is still nevertheless the law in India makes the person as an assessee, as an agent of the foreign party, because the foreigner is receiving an income from him, and if you are held as an agent, you will make an assessment on him, though you will not recover tax by way of withholding tax from him, but you will make an assessment on him as an agent, and that is going to be detrimental to the taxpayer, because again you are doing it retrospectively. However, as far as Vodafone is concerned, if this recommendation, either of the recommendations are accepted, in my opinion they should have a better time for celebrate rather than bothering about these.
All right, so should Vodafone start celebrating? Mr. Ketan Dalal, your view really on how we're going to see the government proceed forward on this one?
Well, first of all, I think Anuradha Dutt and TP Ostwal have said most of it, and I think the choice before the government is essentially either a circular or an amendment, and I think in a matter like this, I don't think a circular can be issued, and I think the finance minister said yesterday that once the Shome panel recommendations are out, then they are not necessarily going to wait for the budget session, and they can make amendments in the winter session as well. There have been various cases where something called a Taxation Laws Amendment Act is introduced. So I think an amendment is, if they accept the recommendations, of course an amendment would have to be done. And I would sort of partly disagree with TP Ostwal when he said that whether they can accept. I think they can, they should, and I think it will send out all the right signals. But as I said, I think an amendment in the law would be necessary.
India's #1 news app just got even better. Download NDTV's new app. Fully optimized for retina display, full screen view, faster response time, and Sudoku. NDTV's new iPad app. Download now.